Welcome back, everybody. Today's topic is going to be about contract fundamentals. So we're going to start studying contract law. For all of you in this class, it should be a review, so none of this should be brand new to you. However, I know it probably has been a while since you've really looked at the basics of contracts. So let's get started. So let's start out with the basic definition. A contract is a single promise or a set of mutual promises, the performance of which is recognized as a legal duty and the breach of which will result in a remedy granted to the non-breaching party. Now that's a lot of words for, hey, we promised each other we were going to do something, and if one of us doesn't do it, then the other one's going to have to pay. That's the basics of a contract. Now there's 4 different categories of contracts. We're going to cover all 4 of these categories in today's slideshow. You've got your type, which is either unilateral or bilateral. You have your method of formation, which is either express, implied, or quasi. And then you talk about the validity of the contract. Is it void? Is it voidable? Is it unenforceable? Or, the one that's not listed there is valid. You have a lot of valid contracts as well. And then the status, is an executory contract or has it been executed? So let's dive right into type. Okay, so what's the difference between a unilateral versus a bilateral contract? Well, if you just look at the words themselves, uni means one and bi means two. So a unilateral contract is one in which there's only one promise, and a bilateral contract is your traditional contract where there are 2 promises. So unilateral contracts, let's look at this slide. In the picture you have somebody returning a dog, a lost dog, and the reward was $100. And the gentleman is getting paid $100 for returning the dog. This is the traditional example of a unilateral contract. Now, these 2 gentlemen have never met before today. However, one of them, the man in the red vest, obviously posted a lost dog sign and said, I'll give you a $100 reward if you return my dog. This is a unilateral promise to anyone who should return that dog. It is not a mutual exchange of promises between 2 specific parties. That's what makes it a unilateral contract and not a bilateral contract. So that falls under number 2 on this slide, where there is an offer to the public that clearly contemplates acceptance only by performance, such as an offer of a reward for the return of a lost item. The other way you can do a unilateral contract is you may know who the other party is. But if I make an offer to you and I clearly indicate that performance is the only way that you will be showing acceptance of this contract, acceptance of this offer, then that also can be considered a unilateral contract. And those are the only 2 ways in which those exist in today's society. The next one is our traditional contract, which is a bilateral contract, and that's where a promise is given in exchange for another promise. Very simple. I promise to cut your grass if you promise to pay me $100 for cutting your grass. It's a mutual exchange of promises. If we both agree, then we have a contract. Now, the Uniform Commercial Code I'm going to bring up because a unilateral contract or a bilateral contract, if it's between you and me as individuals, then traditional contract law, common law, and statutes apply. However, if one of us or both of us is a merchant or a business, then different standards apply to us. And the law that covers us is called the Uniform Commercial Code. You notice the word commercial, commerce, business, okay? It's the Uniform Commercial Code. It says, hey, you are a merchant, you are held to a higher or a different standard than a regular individual. And this helps protect consumers, and this also helps basically keep business and commerce moving smoothly forward. So under the UCC, a bilateral contract is going to exist either by mutual exchange of promises. 2 businesses, Walmart and Target, agree that they're going to, Walmart's going to sell 100 widgets to Target, and Target's going to pay $500 for those widgets. That was a mutual exchange of promises. But also the UCC says, hey, if we've skipped the mutual exchange of promise portion of it, and somebody just starts to perform, Walmart delivers 500 widgets and Target pays for them, it's still going to count as a contract, a bilateral contract, because both parties performed. So how do you form a contract? Well, there's three different ways. There's express, implied, or quasi. An express contract is one that is formed by specific words, and it's either oral or it's written. Very simple, right? It's what we all know. Either you spoke the words or you wrote them down. An implied contract is a little iffier. It is still a contract, but some people don't realize that they're involved in a contract because it isn't spoken. In fact, it's implied. And the example on this slide, I think, gives you a good picture of what an implied contract is. Every day when you go into the bathroom and you turn on the light and you turn on the water, you are accepting the utility services. That brings to you the obligation to pay for those utilities used. You may not have specifically, if you live in an apartment, your landlord may be the one who has contracted with the utility company. You have nothing to do with these people. But by using the electric and by using the water, you know, and everybody knows that you need to pay for that in some way, whether it's through your rent or whether it's directly to the utility company. It is implied that when you use something that is available to you, that you are going to have to pay for that. So that's a really good example of how implied contracts work. A quasi-contract is something even less tenable, okay? It's something that you just can't put you can't wrap your mind around because it seems like, how could that possibly be a contract? Well, the word quasi means it's almost a contract. Okay, it's not quite a contract. It's a quasi-contract. It's actually what they term a legal fiction, which means it is something that was created and fabricated by the courts. It doesn't even really exist. It's not an actual contract. But if the courts did not turn this situation into a contract, somebody was going to lose out, and justice and fairness would not prevail. So quasi-contracts are there to sort of help that person who suffered some sort of a detriment or suffered some sort of a loss. And in order for them to have any kind of a remedy for that, to get payment or to be made whole again, the court has to sort of invent this contract that possibly existed. So here's the example that's on the slide, and I think it can give you a picture of what a quasi-contract is. So let's say there's an unconscious accident victim laying in the middle of the road, and a doctor happens to come by. That doctor who performs medical services upon this unconscious accident victim, who does not have the capacity to consent to a contract, that physician can later bill for her services because she resuscitated that victim. There was no real contract made. The victim couldn't have possibly consented to these services. But in order to pay that doctor, the law was going to create this legal fiction and say that a contract actually existed. For example, when 911 is called, if you're unconscious laying in the middle of a store and they call 911 and the ambulance comes to get you, you still have to pay for the ambulance. And that's where it's a quasi-contract. It's implied that you consented. So are contracts valid? Well, let's presume that good contracts, if we followed all of the fundamentals that we just talked about, then that's a valid contract. But sometimes contracts are not valid. And in that case, they're either void, voidable, or unenforceable. A void contract is something that had no legal effect from the very beginning. That, for example, a contract with somebody to commit murder. Does not have a legal basis, and it is not a legal contract. Therefore, it's never been a contract at all, and it's void. A voidable contract is one in which both parties may choose to avoid later or to ratify later. Most contracts are voidable or contracts that you make with minors. So let's say you make a contract with your 16-year-old neighbor to buy a car from you. You don't go through the parents, you go through the minor. When that 16-year-old turns 18, the 18-year-old can decide whether or not to finish making payments to you or to give you that car back or whatever. That child, that minor, it's called, they can make it avoidable. They can avoid the contract when they turn 18, or they may choose to ratify the contract, which means once they reach the age of majority, they can choose to stay in any contracts they made while they were a minor. So the best way to avoid this is to what? Not make contracts with minors. And then an unenforceable contract is one that was formed correctly. Everything about it was right. You've got your mutual exchange of promises, you've got your offer, you have your acceptance, everything's legal, it wasn't made with a minor, but something about its formation or something about it makes it not enforceable by the court. Say, for example, statute of limitations has expired. Maybe it was the type of contract that needed to be in writing, and it wasn't. It was just a verbal contract, and the statute of frauds applies. And sometimes contracts are just unconscionable. For example, hiring somebody, an employment contract where you pay them 25 cents an hour to pick fruit for you, is unconscionable, and a court is not going to enforce that contract. And finally, the status of a contract. Is it executory or is it executed? Now, these terms are pretty easy to remember. An executory contract is one in which it's still going on, it's still pending. So if you've hired me, if you've contracted with me to build your house and I'm not done building it yet, that contract is considered an executory contract because it's still ongoing. And this next slide, the minute that contract, minute I finish building your house and I've completed all the requirements and you paid me my money, it now becomes what's called an executed contract. It is completed, it has been fully performed, and there are no remaining obligations and duties under that contract. Therefore, it's called executed. One of the ways that I remember the difference between this is if you execute somebody, they're dead, they're not coming back, it's over. So an executed contract is a contract that has been put to the electric chair. Well, that's all I have today. If you have any questions, as always, don't forget to contact me, reach out to me. Have a good day.